Hello, and welcome to my presentation titled How Federal Employees Manage the Challenge of Implementing the Endangered Species Act. My name is Elizabeth Jackson, and I'm a recent master's graduate of Oregon State University. I developed my final report under the supervision of my major professor, Dr. Robert Lackey. During this presentation, we will dive into each stepping stone topic found along the fish ladder, beginning with a brief introduction, followed by 6 lessons learned that I extracted from my internship observations. Last, I will narrate my conclusion. Through Oregon State University's Professional Master's Program, I participated in a comprehensive internship in lieu of a traditional thesis that exposed me to real-world work situations. My internship lasted over a year, where most of the interactions were done virtually. After the internship, I developed several lessons learned. The primary component of my internship was with the U.S. Fish and Wildlife Service, specifically units of the Ecological Services Division. There are 3 U.S. Fish and Wildlife Service offices located in Washington State. Lacey serves as the regional office, while Spokane and Wenatchee serve as field offices. Other major components of my internship include the American Fisheries Society Western Division and the Washington Department of Fish and Wildlife, which operates 6 regional offices throughout the state and has headquarters in Olympia. Minor components of my internship include the Upper Columbia Salmon Recovery Board, one of 7 regional salmon recovery organizations in Washington created by the Washington legislature, and the Center Valley Animal Rescue, a wildlife rehabilitation nonprofit located in Quilcene, Washington. The key legal drive of my internship activities was the Endangered Species Act. The ESA was passed by Congress in 1973 with strong bipartisan support. The lofty goal is to recover species so protection under the law is no longer needed. The law does not protect species or ecosystems when the populations are facing little danger of extinction. Congress had intentionally passed a federal mandate that possessed vague or ambiguous statutory language. It was expected that the government or the courts would eventually fill in the specifics of what the law meant in practice. For early years of the act, bureaucrats, such as federal employees, often with scientific training and not statutory interpretation, were entrusted to implement the ESA. Initially, legislatures thought that the ESA would be an expression of concern to protect the more charismatic, nationally treasured birds and megafauna. Today, the ESA has been a strong source to reference in political and legal disputes, particularly to challenge the U.S. Fish and Wildlife Service interpretations of the vague or ambiguous statutory language. Effectively, anyone can challenge federal government interpretation of the ESA to comport with their own values, where litigants are granted legal standing and do not have to show tangible evidence of harm to sue. ESA bureaucrats must constantly deal with significant political pressures to list or not list a species, while providing objective, policy-neutral information when interpreting the ESA. Another challenge is how listing a decision is made solely based on the best available scientific and commercial information. Additional scientific research cannot be contributed before determining the listing of a species. The ESA forces society to confront the question, how much is a species or biodiversity worth? And who should bear the cost of recovering the species? These are difficult questions to answer, resulting in criticisms of the law from all sides of the political world, even questioning whether the mandate works to recover species and protect species from extinction. I want to briefly touch on the public's perception of scientists, because science is often packaged to advance an agenda and sell policy preferences for any party or organization and in every policy position. Looking at the pie chart on the left, in 2019, a Pew Research Center poll found that roughly 44% of US adults say scientists' judgments are just as likely to be biased as others. The same poll found that only just over 1/3 of Americans believe environmental research scientists can be relied on to provide fair and accurate information about their research all or most of the time. So why is there such a low level of trust? Although people may naively expect scientists to recommend which decision to choose, scientists in neutral roles cannot recommend which decision to pick, as this is beyond the scope of science. The goal of my internship was to determine how employees manage the challenge of implementing the ESA. These lessons are not absolutes. Instead, they are probably applicable in many situations related to ESA policy and decision making, intended to inform an audience about the challenges of implementing a powerful yet contentious law. For my first lesson, ESA scientists or bureaucrats are expected to implement laws impartially. This can be challenging when those employees have strongly held personal political views about the at-risk species under review, or have different interpretations about the role they play in government. So in lesson 1, I found there was extensive communication between the Fish and Wildlife Service's field and regional offices, as well as headquarters, despite continuing education training on subconscious biases and objectivity. As a result, senior leadership supervision can assist ESA bureaucrats from inserting their personal values as they see it to establish consistency in how the ESA is implemented. Based on my observations, ESA bureaucrats can, to a degree, promote recovery for less charismatic species. They can market their personal policy priorities to managers to be assigned their preferred species, and often openly supported policy trade-offs related to habitat conservation of at-risk species. However, ESA bureaucrats were direct to report conflicts of interest if they serve on the board of a professional scientific society. During my internship, technical meetings and discussions frequently referred to the scarcity of information about a species to make the most informed decisions using the best available science, and adequate funding towards research was advocated for. When a policy decision is needed, there is pressure to make a finding, regardless of the extent of species abundance or trends data available. ESA scientists must be able to draw impartial and credible policy options with incomplete information, even if it presents uncertainty, all the while defending their recovery plans against opponents that call attention to this limited data. A warranted but precluded finding can be a result of the agency having too heavy of a workload at that point in time to implement the listing. This finding can also be used to forestall or undermine a decision, especially when the threat of lawsuits is prevalent. Experiential knowledge includes the economic, social, political, and cultural knowledge that has been passed down, whereas scientific knowledge contains the essential characteristics of science, such as objectivity, verifiability, reproducibility, and predictability. Under the prescriptive Endangered Species Act, species status assessments never consider experiential knowledge, but designating critical habitat or Section 7 consultations can consider it. During my internship, I observed ESA bureaucrats in working group meetings, public presentations, and SSA meetings, encouraging participants to share their experiential knowledge. As a result, new contacts that might be able to contribute additional best available science were mentioned during these conversations, but Fish and Wildlife Service employees adhered to the rigid standards of the Act by excluding experiential knowledge in species status assessments. During the internship, Fish and Wildlife Service staff were not receptive to the courts setting their workloads and priorities. Instead, Fish and Wildlife employees feel their decisions should be maintained in the judicial processes, given their finding was developed to be upheld through litigation. Fish and Wildlife Service employees were exasperated when the courts redefined ESA language, and court intervention or new petitions sustained a heavy workload for controversial at-risk species, especially if a court decision influenced future listing and delisting determinations in similar ecosystems. From what I was able to observe, Fish and Wildlife Service employees dealing with litigation on a regular basis were more susceptible to burnout due to strict deadlines, as well as becoming cynical of ESA implementation due to the lack of progress. Therefore, staff working on ESA-related responsibilities for extensive periods would rotate out of these positions to prevent burnout and frustration. Fish and Wildlife Service employees view climate change as a broad threat to species recovery and conservation, and they seem frustrated to be limited to recovery efforts that last decades instead of centuries. If we examine the expanding human ecological footprint in the top right corner, the U.S. Census Bureau, and in the bottom right corner, the National Research Council, projects the population of the U.S. to increase dramatically. Specifically, the Pacific Northwest population could increase by 4 times the current population size. Interestingly, ESA bureaucrats were unlikely to acknowledge the growing human ecological footprint as the primary factor driving species changes, since it is outside the purview of ESA implementation. However, sharing predictions about how these policy drivers may impact at-risk species abundance and distribution can proactively inform management and the public about the necessary conditions for a species to sustain their populations. Implementing ESA policy and regulations is politically charged and involves making decisions between unpleasant trade-offs. The Fish and Wildlife Ecological Services Division is merely one of the many players in the contentious debate over at-risk species management. Nowadays, ESA bureaucrats appear to have diminished authority compared to courts and other groups, since lawsuits, including closed-door settlements, congressional legislation, political powers, social interests, and economics forced the Fish and Wildlife Service to implement the ESA in ways that they were not prioritized, preferred by many agency employees. Elected officials, senior bureaucrats, and appointed officials can also directly influence species recovery and conservation based on a shift in values and attitudes towards ESA implementation. Still, institutions that manage the natural resources within a given geographic area can try to find common ground with the alignment of management objectives to fulfill ESA objectives. To conclude, ESA implementation is analogous to a game of chess rather than checkers, since multiple roles and strategies can affect the outcome. Playing an objective role in government takes diligence and practice. Fish and Wildlife regional offices and headquarters must constantly communicate with field offices to prevent staff from going rogue. ESA implementation can be a frustrating process to bureaucrats and may lack progress. ESA bureaucrats differ in how they view the challenges of implementing, where some interpret at-risk species recovery as a glass half full, a glass half empty, while others might view it as water in a glass. I'd also like to provide a couple acknowledgments for my final report, including Dr. Robert Lackey, my major professor and co-author, my graduate committee, my graduate advisors, internship supervisors and contacts, as well as my editors. And I'd like to leave you with my contact information. Again, I'm a recent graduate from Oregon State University, and I'm currently employed by the Cascadia Conservation District out of Chelan County, Washington. And you can reach me at elizabethjackson7000@gmail.com. Thank you very much.